We all heard the news when the Court of Appeal ordered that GN Savings and Loans should have their license reinstated. What actually happened in court? When the Bank of Ghana revoked the license of GN Savings and Loans, Dr. Indum fought back. He went to the High Court arguing that the regulator had ignored something critical. The government of Ghana, its ministries and agencies owed his bank a substantial amount of money. The Bank of Ghana, on their part, put the figure at around 30 million Ghana cedis. Dr. Indum said that number was a gross underestimation. At the regulator's actions, he argued that his property rights, his right to administrative justice and fairness had been trampled upon, and he wanted his company back. The High Court sided with the Bank of Ghana, but the Court of Appeal saw things very differently. The first thing the appellate courts addressed was a fundamental legal question of who bore the burden of proof. The High Court had placed the burden on Dr. Indum. The Court of Appeal said that was wrong. It was the Bank of Ghana that revoked the license. It was the Bank of Ghana making the positive claim that it acted lawfully in revoking the license. So it was the Bank of Ghana that had to prove the fairness of what they did. And then came the next question of whether GN Savings and Loans was actually insolvent. The law allows the Bank of Ghana to revoke a license where a financial institution is insolvent or is likely to become insolvent. Insolvency in that context can mean one of two things. Either the institution cannot meet its obligation as they fall due, that is the cash flow test, or its liabilities exceed its assets, that is the balance sheet test. The High Court applied only the cash flow test and found that GN Savings and Loans had failed it. The Court of Appeal said that was not enough. A regulator acting fairly cannot simply pick the test that suits its conclusion. You cannot declare an entity insolvent when it holds assets that are far exceeding its liabilities, assets that, if realized, could cover every obligation. Insolvency, the court held, must be assessed by looking at the full financial picture. And when the court looked at the full picture, something extraordinary emerged. Dr. Indum had tendered interim payment certificates, IPCs, documentary proof that entities connected to him were owed money by the state. On the surface, some of those certificates did not appear to directly involve GN Savings and Loans. But then it emerged that Gold Coast Advisors Limited had assigned a portion of its debt, nearly 630 million Ghana cedis, directly to GN Savings and Loans. So GN Savings and Loans had stepped into the shoes of Gold Coast Advisors. Those debts became assets on GN Savings and Loans books. GN Savings and Loans had a capital deficit of 344 million Ghana cedis. On the evidence, the state owed them nearly 630 million, so the bank was not insolvent. It was a creditor of the very government that shut it down. Where still, the value of those IPCs was still being worked out with the Ministry of Finance at the time the license was revoked. The numbers were not yet final. Dr. Indum had no choice but to rely on audited accounts as evidence of what he was owed. A regulator that was serious about fairness would have paused and would have ordered an independent inquiry. It should have waited for clarity before pulling the trigger. The law, in fact, required the Bank of Ghana to properly ascertain the assets and liabilities of the bank before acting, and there was no evidence that this was done. And then there was the matter of the supervisor. Before revoking the license, the Bank of Ghana had appointed a supervisor to monitor GN Savings and Loans. The supervisor's recommendations did not include revoking the license. In fact, the supervisor commended the bank's wide reach. It had broader coverage than even Ghana Commercial Bank and extended deep into rural communities. The supervisor called for liquidity support for the bank. If the Bank of Ghana was simply going to override that recommendation, it needed to explain why, and it gave no reason. The Court of Appeal's conclusion was unambiguous. The Bank of Ghana's conduct was unbalanced, unfair, and unreasonable. It's a remarkable thing when a court has to say this very plainly, calling it absurd, irrational, and unjust for a government to owe a bank so much money that the bank's books suffer, and then for that same government to turn around and declare the bank insolvent. The license of GN Bank was ordered to be reinstated. Let me know your thoughts in the comments. Follow Super Law GH Studios for more real stories, real cases, real people.